Hey everyone, so I'm probably going to get a lot of pushback on this video, but I've been sitting quietly and trying to not talk about this, but I just reached a point where I don't care. I'm going to have an unpopular opinion here, and that should be okay. I definitely don't expect everybody to agree with some of the things that I'm going to say. And again, that's okay. You're absolutely free to have whatever opinions you want, as am I. So, what I want to talk about, as I'm sure was pretty obvious in the title, is not how I think Michael Long is some super awesome dad of the year. Because let's get something straight right away. I do not, and I have not ever been somebody who supports Michael Long. I have, however, always, from day one, been Team Sophie. I believe what she said happened to her. I believe that her fear was real, and I believe that she went through something no child should ever have to go through. What I'm not going to do in this video is get into the details and the nitty-gritty and talk about theories and brainwashing and all the nonsense that's been out there and allegations made by people who have no idea what they're talking about. Because none of us know. All we know is what that little girl told us. I believe her. I will always believe her. And I stand with Sophie. Now, that aside, what Michael has done is absolutely wrong, stupid, the dumbest bonehead move that he could have made. I am absolutely livid that he has disappeared like he has. And no matter what my opinions are on Kelly, she has a right to know where her daughter is. And I'm furious at Michael for making this the situation that it is. However, after reading a lot of documents, I've really, really come to realize just how corrupt things seem to be in this case. They are absolutely not what we think they are. None of us, either side. Like, it's crazy. I read the Mandamus Mandamus, I think is how it's pronounced. I've been saying it wrong. I read through that along with some testimony and some of the court transcripts because contrary to public opinion, it's not really under seal. And besides that, as long as I came by this information through legal means, which I did, I'm not under the Court of Texas jurisdiction, and nobody can tell me what I can or cannot share. I'm not breaking any laws. This isn't under seal. So all of you that are going to come screaming at me when I start talking about this, you can save it because honestly, I don't want to hear it. What other people have shared, the graphic nature of what they've shared is vile. And what I'm going to talk about is nothing compared to what has already been put out there. And put out there by who? A lot of people will jump really fast and say Michael did it. And yeah, he did. He put that first video out there because he really didn't think he had any other choice. And more unpopular opinion here, I believe that he believed he was doing what he did to protect his daughter. But that's where any shred of respect for me ends for him, because his behavior from there on has been abhorrent. Is he a good guy, husband? No. He's trash in my books. However, I do believe he loves his children. And I believe that he thinks that he is protecting Sophie. And I don't know, if I was being forced to send my child off with the woman who we all saw, millions of us saw, the way she treated that little girl, the way she spoke to her. And I'm talking about Grandma Kim, the gaslighting, invalidating grandma. You can't have been through that. You can't be so unhappy. You had the lead role in the play. Give me a break, okay? We watched as she and Kelly Long tried to drag that child, kicking and screaming, causing her injury, from a vehicle. That right there was abuse. So don't come at me and say it's all lies, it's all made up, it's brainwashing. Kelly's great mom, she never did anything wrong, because we saw her harm her daughter. We also heard the 911 calls, and we know that she continued to let those kids live in terror for months upon months. We also know that even after a court order was issued that did not allow Jake to be in the presence of those kids, whether you think he's innocent or not is completely irrelevant at this point. I don't. However, he was barred from their presence. She broke that court order. And as a result, one of the boys was injured in an accident. So, don't come at me saying that Kelly Long is Mother of the Year, because it just ain't so. That little boy had to have surgery because he was riding four-wheelers or go-karts or whatever it was with Jake. And he was hurt as a result. A direct result. Had Kelly followed the court order, that never would have happened, would it? I'm going to play a few clips from Nick Rakita, who is an actual lawyer and has no reason to have bias. He has no affinity for Michael and has straight up said that what he did was trash. However, he has a problem with seeing the clear corruption and the unfairness in the system and how badly this court case has been handled. I'm going to go over some documents and discuss and just some parts of what I read in the transcripts and in the writ, and why I think that despite the fact that he's probably going to lose, and that now that he's done what he's done, Michael has lost any chance, I think, at legally retaining custody. So poor Sophie. But anyways, before I do that, I just want to share some of these clips with you first. People on the opposition keep saying that anyone who opposes Michael Long is getting doxxed, getting threatened, getting harassed, when the truth of the matter is, it's so the other way around. And the next little bit of information that I'm going to share here is absolute proof that Kelly's lawyers are breaking the law.
If you have the petition and want to avoid any legal exposure, you should delete this petition in its entirety. Here, Miss Elkind is offering unsolicited legal advice to a potentially represented party or unrepresented party that is adverse to her, without a contravening statement that she is not his attorney and cannot provide him legal advice. As a layperson, Spectre, who is also lovably low IQ, that's a joke, cannot be expected as a layperson to understand that this is not his attorney and cannot give him legal advice. If, in fact, since they are threatening legal action against him if he does something, cannot ethically give him any legal advice at all. You should delete the petition in its entirety, including all attachments and exhibits, from all devices, and refrain from sharing or disclosing in any manner all or any part of the petition, including all attachments and exhibits and any information contained therein. Thank you, Laura Elkind. And this is very similar to the email that she sent to Kiwi Farms' Ken Jennings, which contained the same breaches of her ethical responsibilities. As a lawyer, if I were to send a cease and desist to someone, I am professionally obligated to inform them that I cannot answer legal questions. I cannot give them legal advice, and they must consult an attorney that is within the jurisdiction and licensed to practice law and is familiar with them to get those legal answers. I am basically required to do so. and Laura Elkin has failed to do so after lying twice, materially misrepresenting legal information about these documents. So, Spectre report replies, Miss Elkin, I'm interested in reading the sealing order issued by the court concerning this petition for writ of mandamus filed by Michael Long. As you are aware, an individual not a party to a case cannot be ordered to not share legally obtained documentation in which receipt was not enticed via illegal measures. Nice summary. Further, as someone outside the jurisdiction of the court, indeed outside of the state of Texas, the court has no authority to order me to do anything regarding this case. Also, mostly correct. It could, but it'd be an argument. You're generally right here. I would also point out that even if the petition is sealed, the order to seal would not be and would be accessible to the public to confirm this. Spectre is accurately stating the rules of civil procedure in Texas. As there is no order in this case from the Fifth Court of Appeals website available on Pacer or any other service, it wouldn't be available on Pacer, but it would be available directly from the Court of Appeals website, which there still is not an order sealing this case on the Court of Appeals website. Service for checking such a thing. I've requested to see this from a lawyer who is supposed to be representing a party to the case. I will also take a moment to point out that you have bolded a portion that appears to be legal advice specifically to draw attention to it. That could be viewed as an ethical violation as well, as you do not represent me in any capacity. The advice is unsolicited, and you are offering it to someone who could be an adversary in a legal proceeding, assuming what you are saying is true. As I said to your receptionist, Sarah, I would like to see the actual order to seal the paperwork signed by the judge, not a proposed order, the actual signed order. I await your reply. Thank you. I picked the best shows to do these. Ms. Elkind, I am replying to update you on a development. I spoke with Claudia, the deputy clerk of the court for the Fifth Court of Appeals where the writ was filed. I was informed by the clerk that there is no seal on the petition. Furthermore, the writ and associated filings are available to the public to obtain in person. They simply aren't available online because of certain sensitive data. I would like an explanation as to why you not only misrepresented the status of the petition, that it was sealed, that you threatened me with legal ramifications if I did not comply with your demands to delete or remove the items, knowing full well that what you said was false. As you are aware, this is a severe breach of ethical standards for a lawyer, and you should know that since you have over 25 years experience in practicing law. I await your reply. Her response. My understanding was the Court of Appeals was aware of the sealing order issued by the trial court. Doesn't matter, by the way. That's a separate cause of action. That is a separate action in a separate court. Does Laura Elkin, do you think that the trial court can bind the appeals court? Of course, she doesn't think this. Can bind the appeals court to a sealing order? It cannot. The court would have to issue its own sealing order. I understand that the sealing order has now been filed with the Court of Appeals. Oh, has it? Whoops. The petition for writ of mandamus contains highly sensitive personal information about a private custody dispute involving 3 minor children. Hence my demand on behalf of my client, Kelly Long, that you refrain from disclosing this highly sensitive and private information. Thanks. Ms. Elkind, I'm going to need to see a copy of this order signed by the trial court judge. You have to understand that you went from this is under seal and not available to the public and threatened me with legal ramifications to I was under the impression the appeals court knew about the trial court sealing this case, but now we have filed it, so my cease and desist applies. This seems to be something rather serious, as you have filed the same cease and desist, not just with me, but with another individual I'm familiar with. You've threatened legal action against people based on, at best, a lack of follow through on your part in ensuring the seal was legitimately filed, and at worst, a downright lie because you knew the case was not under seal in the least. In any case, you had no order from the appeals court ordering the information be sealed when you sent the emails out. Second, I asked for a copy of this seal because most recent motion on sealing the case at the trial court level that I can find vacated the 31st August 2020 verbal order to seal the case. Laura Elkin says, give me a break. You're going to broadcast the most intimate private details about 3 little children? Have you no decency, sir? Let me take a moment to remind the court that they have already done this. They have already done this. Kelly Long, through her attorney and PR firm. By the way, all of you people out on the Sophie versus Michael, the Sophie Facebook groups, I know you're watching, or I know you'll see this at some point. For all of you out there, Kelly Long has a professional company with the purpose of influencing your decisions. Why do you think you went from supporting Michael to Kelly after Michael was muzzled? Why do you think the public narrative changed from pro-Michael to pro-Kelly, despite the fact that Kelly has violated numerous court orders, has consistently put the children in contact with Jake Bellington, whom she has been ordered to not have contact with the children? Why do you think the narrative shifted? I'm not going to tell you what to believe, but Kelly Long has hired someone whose literal profession it is to tell you what to believe. You don't know banyan trees. Banyan trees are a great representation. They're massive trees. They don't grow tall, they grow out. They grow out extremely wide. They grow out so wide that their branches become too heavy, and they grow little support branches that will go down and root into the earth to support the weight of the branches that go out. Red Banyan is a national PR firm. Their logo and branding shows their clients that they're there to be an umbrella, to cover every issue, to support every issue, to cast a broad shadow over the truth in favor of their clients. Here's your sealing order, but you're not getting my message. Sealing order or no sealing order, my client will consider all legal avenues available should you publicly disclose her and her children's private matters, including a lawsuit for invasion of privacy. The problem with this, of course, is that none of this has been private at all. My client will consider all legal avenues. That doesn't mean anything. Spectre report says, Miss Elkin, I had no intention of posting anything personal, including the names of the children nor any medical information. My requests, you will notice, were specifically aimed at ascertaining the validity of the claim made by you in multiple cease and desist letters, including one you sent to me, when the intent of me contacting you was from the beginning that the petition is under seal from the court. Nothing more. At no point did I mention providing the document in full to anyone, nor make any claim that I would publicize anything. You made threats when I wanted an answer to a simple question. Is it under seal or not? Thank you. This is a message I got from my secretary, is that you wanted to know if a motion was under seal because you did not want to get in trouble talking about it. Ms. Elkin, my statement to her was, I cover legal issues on YouTube, and I'd like to talk about this motion. At no point did I say I was going to release the motion to the general public, merely talk about it in, say, a video. However, since I had seen emails purporting to be from you, claiming to be a cease and desist because it was under seal, I sought to make sure this was legitimate in my due diligence so I could cover that as well. I should have called you back and not just assumed you were another YouTuber wanting to publish the motion. That would be me. I don't want to. I'm going to. And I believe we were talking past each other. You focusing on the order and me focusing on the privacy issues. And the fact the sealing order is entered reflects the privacy interests the court is seeking to protect. If you were an attorney, you should have told me, are you? Spectre says, I am not a lawyer. No, the most I have done is pre-law in college and worked at base legal in the Marines. Had I been an attorney, I would have informed you out of courtesy. Even then, the broadcast and publication of those most sensitive documents cannot easily be abridged by the court, and certainly not a court who does not have jurisdiction over the parties involved. If anyone is telling you otherwise, they are lying to you, almost like they have a lawyer and a PR firm dedicated to lying to the public for the purpose of controlling the media narrative on this case. Sensitive government documents recorded illegally and then provided anonymously to broadcasters, so long as the broadcaster did not participate or induce the illegal recording or illegal production of the recordings, the broadcaster has a First Amendment right to cover and play in their entirety those recordings. It's a long-standing First Amendment law. Again, go learn it. Don't let lawyers lie to you. Go learn it. Don't let lawyers lie to you.
Yes, it is.
Okay. The court has not ruled on the motion yet, if that's what you were.
Well, I have a question. I'm being told by a lawyer that is supposedly representing one of the parties, Kelly Long. She sent me a cease and desist because I'm in possession of the petition for writ of mandamus. She has sent me a cease and desist claiming that there is an order sealing the writ, the petition, as well as I think all documents related to it. Can you confirm if there is an order to seal it on file?
I don't see an order, and it's not sealed. It has sensitive information on there.
I'm.
Notice what she said there. I don't see an order, and it's not sealed. It has sensitive information on there. Because it involves children in a custody dispute, it's going to automatically be restricted from internet access, not public access. You can go in and get the documents, which will be covered on this in just a second.
I'll transfer the call to our chief deputy clerk, because she's the one that handles all the mandamus cases, and she's the one that posted the document to the case.
All right, excellent. Thank you very much.
Okay, please have your the mandamus case number ready. Okay.
I got that ready.
Okay, please hold.
Sure.
This is Claudia.
Hi, my name is. I am paying attention to a case that's been filed in the Court of Appeals for the Fifth Court of Appeals, and I received a cease and desist from a lawyer who is representing one of the parties in it. She claims that this specific petition for writ of mandamus is under seal. I didn't find anything on, already. I didn't find anything sealing it, but she said that there could be legal consequences. I just want to get from you, is there an order to seal this writ or not? I know there's sensitive information in the petition, but is there an order to seal it?
What's the appeal number?
05 TAC 21 TAC
dash
005 74 TAC Charlie Victor.
It's dash. What's wrong with you? Tack.
Okay, no, there is. This is not a sealed petition.
Okay.
It's just not posted to the web because it looks like there's sensitive data, like a child's birthday.
Okay. Yeah.
And stuff, and so that's why it's not posted to the web. But it is anybody can come up here and get a copy of it because it's not sealed.
Okay. Excellent. Thank you very much. I guess this lawyer absolutely 100% lied to me.
Come on, Inspector. She can't talk about that.
I don't know about that. All I can do is tell you that it's not sealed. There hasn't been a motion to seal it. It's just not posted.
Well, the lawyer specifically says that it's under a court-ordered seal, so.
Well, not here.
All right. Excellent. Thank you very much.
You're welcome.
You have a good day now. Bye-bye.
Available, by the way, under the Texas Rules of Civil Procedure, and I would assume the Texas Rules of Appellate Procedure, an order sealing a case must be publicly accessible and viewable. You cannot seal a case without an order that is publicly reviewable sealing the case, because the public has a right to know if a case is sealed or not. Again, go research it. Don't take my word for it. It's right there.
Now that we have that all out of the way, we're going to take a look at this writ of mandamus and some of the issues that were brought up. And quite frankly, I found a lot of it really quite concerning. Whether I like Michael or whether I hate Michael is irrelevant. It's still completely concerning. So I'm just going to read through some of these quickly. The issues presented: whether the trial court can order sole managing conservatorship status of a child can be conferred upon an individual that has no standing and that is not properly before the court. So what he's addressing there is the sister that was given temporary custody of Sophie is not even in the state of Texas, was never sworn in, hasn't been considered in a formal way, and it was just sort of arbitrarily said, okay, well, we're just going to give her to them. And another huge problem with this is she's not in Texas. I believe North Carolina is what I've learned is where she's at, which would mean the courts in Texas would have absolutely no jurisdiction over this person. So they wouldn't even be able to compel or order her to bring Sophie back to Texas, to bring her for a court date, to exchange back custody. Texas would have no jurisdiction whatsoever. That in itself is a huge problem. 2, whether the court acted erroneously when it refused to allow for a contested hearing on the recusal motion. So Michael had issue, which we'll see after is actually some legitimate issue, with the appointment of Judge Snipes, and he was not given the proper channels to request his recusal or dismissal. 3, whether the trial court acted improperly when it refused to allow the petitioner to testify while acting in a pro se capacity, and thus denying him the constitutional right to due process. 4, whether the trial court erred when it conditioned the payment of $15,000 paid by Michael Long on whether the petitioner would have contact with the minor children made on the basis of this suit. At the hearings on May 20th, 2021 and July 7th, 2021, there was no testimony whatsoever for the costs of any related expenses associated with the case and whether or not Michael Long had the ability to pay them. 5. Whether the guardian ad litem appointed for the children acted outside of her statutory role, which absolutely they did, and you'll see why when I get to that section. In its May 20th, 2021 order, signed on July 7th, 2021, the trial court erroneously named Danielle as sole managing conservator of one of the children, SL, even though she is not properly before the court, has met no standing requirement delineated by the statute to intervene, and has had limited contact with the minor child, and as such, the trial court has no authority to direct her in any manner. The trial court went further and ordered Ms. to have all of the exclusive rights and duties associated with the minor child. This erroneous ruling essentially precludes both parties' biological parents from any decision-making regarding the child in favor of an individual that has no standing and is not properly before the court. Therefore, if Ms. acts in the capacity in which she has been appointed, neither of the parties that are properly before the court will have the authority to enforce any duty, right, or obligation on the care of their biological child, and the court will not have authority to require any such action on behalf of the non-party. So I can see the concern there, and if I was him, I would not be okay with this placement either. And the only reason I think that Kelly is okay with this is because that's her sister, and she knows darn well she's going to get whatever she wants from her. 2. Whether the court acted erroneously when it refused to allow for a contested hearing on the recusal and or disqualification motion. A. Whether Judge Snipes' appointment complied with Section 74.055B of the Texas Government Code. After Judge Cynthia Willis recused herself in this matter, Judge Ray Willis appointed Judge Michael Snipes. At the time of this appointment, Judge Ray Willis had been active in social media, sharing the child, Sophie Long's medical records with a number of individuals on the same social media platform. Subsequent to that, Judge Willis immediately recused himself from the case once petitioner filed a motion requesting the same. At the time of this appointment, Judge Michael Snipes was clearly not qualified for the appointment to a highly complex family law matter. The trial court clearly acted erroneously by refusing to conduct a hearing on petitioner's motion to recuse and or disqualify. Upon presentation of the motion, Judge Michael Snipes declined to recuse or disqualify himself, thus requiring Judge Stubblefield to conduct a hearing on the motion to recuse or disqualify. When Judge Stubblefield was duly appointed to preside over the petitioner's request to recuse or disqualify Judge Snipes, he summarily issued an order on the 16th day of June, 2021, making several findings in the order, but refused to conduct an evidentiary hearing. This clearly is an erroneous ruling. In re Eduardo Chavez, the Court of Appeals stated, unlike the complaining party in a bunch of citations that you can read for yourself, I'm just going to skip through that, did not have their recusal motions properly denied after a hearing before an assigned judge. The language in this rule suggests to the court that the rule addressed those instances where a recusal motion was properly denied, but does not expressly provide an adequate remedy where the trial judge takes no action or inappropriate action on a recusal motion that is in procedural compliance or denies that the motion essentially on its merit without a referral or even a hearing. The San Antonio Court of Appeals discussed this distinction in its opinion in Flores, bunch of citations. In its review, the court noted that in the cited case, it involved a denial for a motion to recuse rather than a complaint for failure to comply with Rule 18. Based in part on this reasoning, the court determined that it had a mandamus authority. See a bunch of citations again. Finding no remedy by appeal under circumstances where trial judge failed to either refer or recuse, such that the motion could neither be granted or denied. The differences between the facts in these cases, a case involving a clear denial of motion to recuse by the assigned judge, compared to a situation where the relators find themselves suggest this. Sorry, I keep tripping over my tongue. Compared to the situation in which relators find themselves, suggests to this court that Woodward versus Woodward's decision, interpreted in Union Pacific Resources Co. much more broadly than was warranted in the case, and creates a bewildering effect. Summary denial for noncompliance. A. Motion to recuse. The motion to recuse that does not comply with this rule may be denied without an oral hearing. The order must state the nature of the noncompliance, even if the motion is amended to correct the stated incompliance. The motion will count for purposes of determining whether a tertiary recusal motion has been filed under the Civil Practice and Remedies Code. B. Motion to disqualify. A motion to disqualify may not be denied on the ground that it was not filed or served in compliance with this rule. Sorry for the tongue-tied here, but it's a lot of jargon just to kind of get to the point. Judge Stubblefield specified in his order that there were no facts are set forth therein which might lead a person of reasonable sensibility to conclude that Judge Snipes might harbor some bias or prejudice against any party to the current matter pending before the court, which would impair his impartial deliberative function. This is not the standard on a motion to disqualify, as stated above. Further, the statute requires that the motion to disqualify must be heard as soon as practicable, and this was clearly not done. In addition, the statute clearly allows a motion to disqualify to be reviewed by a mandamus. A. Whether Judge Snipes' appointment complied with the section of the government code. Judge Snipes was clearly not qualified to receive the appointment to preside over a family law matter when he received the initial appointment by Judge Wellis, who subsequently recused himself on the matter. As of June 22nd, 2021, Judge Snipes had only one specialty that was listed. His specialty was only as a criminal judge at the time of the appointment. On or about June 22nd, 2021, his specialty was changed to reflect that he had a specialty in family law and could preside over family law matters. It's important to note that this specialty was not changed until after petitioner filed the motion to recuse. And then it references the rules for choosing or assigning a retired judge. List of retired judges and former judges subject to assignment. Each presiding judge shall maintain a list of retired and former judges who meet the requirements of this section. The presiding judge shall divide the list into specialties of criminal, civil, or domestic relations cases. A retired or former judge may only be assigned to a case that is in the judge's area of specialty. A judge may qualify for assignments in more than one specialty. To be eligible to be on the list, a retired or former judge must have served actively as a judge for at least 96 months in a district, statutory, probate, statutory county, or appellate court, or have developed substantial experience in the judge's area of specialty. So it sounds like Snipes wasn't technically qualified. Next, 3. Whether the trial court acted improperly when it refused to allow petitioner to testify while acting in a pro se capacity, and thus denying him the constitutional right to due process. During the hearing on May 20, 2021, the trial court refused to allow petitioner to testify as to the best interests of the children. When asked by Mr. Long if he could call himself as a witness, Judge Snipes told petitioner, "You can't call yourself to the stand, but you can make all the arguments you want to make. You know, I'll accept that. It's just not testimony." See attached excerpt from the court hearing of May 20th, 2021. This is a complete denial of due process and thus a denial of his constitutional rights to the same. Further, the court made a ruling without hearing from one of the biological parents, and as such, making a ruling without said testimony is a failure to determine in the best interest of the children. 4. Whether the trial court erred when it conditioned the payment of $15,000 paid by Michael Long on whether the petitioner has contact with the minor children made the basis of this suit. The trial court awarded expenses associated with the case to respondent and required Michael Long to pay them, even though there was no testimony elicited by any witness that evidenced such case-related expenses. The trial court went on further to condition the payment of said expenses to petitioner's access to the children, specifically stating that he's required to pay $15,000 or that the no-contact period would be extended until such time as Michael Long appears before the court at a hearing he himself schedules to provide sufficient evidence as to why the court should lift the no-contact order. That is illegal in Texas. Support payments, which, well, financial cannot be used to prevent access to your children. It's just not allowed. The Texas Family Code states that a court may not render an order that conditions the rights of a conservator to possession or access of a child on the payment of support. Texas Family Code 153.001B. 5. Whether the guardian ad litem appointed for the children acted outside her statutory role. Judge Michael Snipes, sua sponte, that means of his own volition, immediately appointed John Helms and Stephanie Cole Martin as the guardian ad litem in this matter, and they both readily accepted the appointments, even though both had little to no experience in family law. There was no agreement between the parties regarding the appointment. Specifically, as to Ms. Martin, she is a criminal defense lawyer from Dallas County and lacks child advocacy experience. It's important to note that at the time Judge Snipes appointed the amicus and guardian ad litem, he had been previously in working relationships with both attorneys in the criminal law setting. At the time of the hearing, May 20th, 2021, Ms. Martin participated in the litigation of the case, calling witnesses and arguing to the court, which is outside her role as a guardian ad litem. Specifically, the Texas Family Code sets out the powers and duties of a guardian ad litem as follows. A guardian ad litem appointed for the child under this chapter to attend all legal proceedings in the case, but may not call or question a witness or otherwise provide legal services unless the guardian ad litem is a licensed attorney who's been appointed in a dual role. It's clear that Miss Martin was not appointed in a dual role, and after the court was notified that she was acting outside of her role, he continued to allow her to do so. Now, keep in mind, this is a guardian ad litem, not an attorney ad litem and not an amicus attorney, so she definitely was not in her place to be doing that. And that brings us to the end of the main points of the mandamus that I wanted to talk about. I had wanted to talk a little bit about the transcripts from the hearing that I read because I was quite frankly astounded. But because this video has gotten quite long already, I'm going to stop it there and potentially make a follow-up video discussing that. If people are interested, please let me know in the comments. Again, none of what I'm saying here is me condoning what Michael has done in any way. He is in violation of a court order. And I think what he's done here is terrible. He needs to bring her back. He needs to let people know that she's okay. And he needs to do what's right. He's not going to be able to do anything for her sitting in a jail cell, which is where he's going to end up if he doesn't get it together. Now, he's bought time, I'm assuming, because of this. I don't know what his chances are. I don't know enough about the law. Definitely check out Nick Rakita's video on this. he does a really good job of breaking it down and explaining a lot of the legal jargon, and just I found it really enlightening. And he's not team Michael either, like, just so there's no question about that. Michael, if you happen to be listening, just do what's right. You can't help her if you have her completely taken away from you and you lose complete access. I don't think he'll hurt her. I don't think she's in any sort of danger in that sense. But at the end of the day, you got to do it right. You got to do it the right way. I hope that he's somehow hunting down enough resources and has an attorney helping him out or something. I really don't know. But this has to be sorted, and Sophie needs to be brought home. If you made it this far, thank you for listening. I know that there's going to be some people that are not impressed with me, but I just got to be honest. I don't have to like the guy to know that things don't look right. Things just aren't right. And to everyone out there singing Kelly's praises right now because Michael's done wrong, it doesn't change what she did. She's still not Mother of the Year. She still did the things we saw her do, said the things we heard her say, allowed her children around someone who she was legally barred from having them around. She has put her children in harm's way far more times than anyone's willing to admit. So seriously, it is possible for two things to be true. Michael's wrong. Michael is very, very wrong in what he's doing. But that doesn't mean Kelly is right either. Again, thank you so much for sticking it out and listening and just giving me your time. I really appreciate it. I appreciate all of your support and love on my Murphy videos. There's going to be lots more of that coming. But it's still important to me that I speak up on these issues, and that's what my channel has always been about. That's always been my goal. So please like, subscribe, do all those awesome YouTubey things, and I really, really appreciate you all. Thank you so much, and I will see you in the next one. Again, please let me know in the comments if you would like me to talk about the transcripts, and I will consider if I'm going to go through them or just do a quick summary. But yeah, have a good one, and everybody stay safe.